In summer of 2017, 7-year-old FL told her grandmother about SA incidents involving Alex Castro. A jury found Castro guilty of 2 counts of first-degree child and 2 counts of first-degree child molestation with aggravating factors. The trial court imposed an exceptional sentence above the standard range, and Castro is now appealing. He argues the state committed misconduct during closing arguments by 1. Appealing to the passion and prejudices of the jury, 2. Calling Castro a liar, 3. Vouching for its own witnesses, and 4. Attacking defense counsel. He argues that the improper arguments require a reversal of his convictions. Let's take a look.
Thank you, Lisa Elner, for Mr. Castro. This case comes to us procedurally a little bit different, so I'm going to do something I probably haven't done, which is ask you all a question. This was scheduled for no argument, and then you guys changed your mind and asked for argument. So my thought was, and Ms. Hanlon and I have kind of talked about this, maybe you had a specific question you wanted us to answer. And if not, that's fine. But if you do, I'd be happy to try and answer it. Otherwise, I'll just proceed with my argument.
Let me go ahead and open the box for you to let you know the mystery, the answer to the mystery. When conferencing this case, we thought this was a close case, possibly a reversal. And because it was close, we thought that we would hear arguments and give us the freedom to ask questions. We don't have any specific questions, but we just think this is closer than most cases alleging prosecutorial misconduct.
Right. Thank you. And I also want to say that I take issue with the trial deputy. I find Ms. Hanlon my esteemed colleague, and I'm pleased to have her here on the other side of the aisle with me. So nothing is intended towards her at all. So I think that this case, there's no question there was misconduct. The question is prejudice. And counsel didn't object for the most part. So we have the flagrant ill intention where the courts look at, could the misconduct have affected the jury? I mean, that's really what they look at, what it comes down to, and could it have been cured? And I would argue that in this case, individually and cumulatively, it could not. You have first this appeals to the passions and prejudices by calling all rapists the worst of the worst, worse than a murderer, right? Anybody would rather be charged with murder than rape. And then you have an appeal telling the jury that they owe this victim something. They owe this victim the testimony of a specific witness. So again, that's like cases that talk about, Bellegarde, the madmen and the butchers. Here we have the rapists and the murderers. We have a victim who is owed something rather than let's look at the evidence and weigh it. And this trial deputy has done this before in a case this court issued unpublished opinion. I think it's Stalford, something like that. And I'm not sure who's on the panel from that one. But, in this case, it began with this appeals to the passion, but then you have the deputy holding up a evidence book saying, do you see this is a book on counsel's ethics? This guy said things to you that are not legal. He can't do that. Now, the court did sustain that objection to the first one, but the prosecutor didn't stop there. I mean, that was the remedy. The defense attorney overstepped himself in closing. I'm not disputing that, but two wrongs don't make a right. And under the United States Supreme Court in Young, the prosecutor doesn't get to commit misconduct. The prosecutor can set the record right. The prosecutor can say, let's look at the evidence here. And this is what it shows. And that's
Counsel, let me interrupt you there.
Sure.
There's no objection. You've correctly stated the standard of review.
Yep.
Tell me why an instruction would not have cured this had there been an objection.
Okay, because there was too much of it. You have the prosecutor
Explain that. What do you mean too much of that?
Let me explain.
Well, I'm asking you to.
I'm getting there. Calling the defense attorney unethically, basically the message is, this guy is not trustworthy, ignore him. Twice he calls Mr. Castro a liar. When you get caught, you lie.
Counsel, let me interrupt you there.
Right.
Again, I've reviewed the record. I don't see where the prosecutor called him a liar. I do see where the prosecutor did say it's a lie. And there's a distinction, I think, between calling somebody a liar and calling the argument a lie. That's what, the fallacy of ad hominem is all about. So I want to be clear, if I'm misreading the record, that you can correct me.
Yeah, I think you are, actually. It makes no sense. You have to lie about that. He uses the word lie, but I would disagree with your proposition that there's a difference between somebody making a statement and the prosecutor saying that's a lie versus you are a liar. They're the same. If I say my hair is green and you say that's a lie, you're telling me I'm lying. There's no distinction. So he says that makes no sense. You have to lie about that. Then he says, this is ludicrous. The defendant has zero credibility. You have to come up with the most ridiculous lie. Defendant is not a credible witness at all. He's calling Mr. Castro a liar. But he doesn't stop there. So where you get to the can't be cured, so he repeatedly says he's a liar, and then he says, okay, this victim is telling the truth. You can't make that up. This is a body sensory memory. So he's violating, he's expressing his personal belief with matters outside the record, because there was no expert to talk about body sensory memory, whether one can or can't make something up. He simply said that. And then he says, he says, let's see.
Ms. Zellner, to focus you a little bit better here, what concerns the court more is when the defense during closing was making improper arguments and the prosecutor objected and the trial court sustained the objection. But despite sustaining the objection, the prosecutor went after defense counsel personally, maybe, saying something's a lie, isn't calling them a liar. Maybe it is, maybe it isn't. But then the prosecutor also said that this argument wasn't legal. These are some of the things, once the objection was sustained, there was no reason for the prosecutor to continue that line of argument. And so that's what we're kind of more concerned about. And I think the panel is in line with Judge Melnick's thinking, is that what happened was wrong. It was improper. The argument was improper by the prosecutor. But why is this reversible under this very high standard? Why couldn't this have been cured by an instruction from the court, basically saying, I sustained your objection, Madam Prosecutor, please go on with a different line of argument. Jury, ignore those last two comments. Why couldn't that have cured the prejudice?
Right. Well, and I think that cases like Reed, where there was an objection, where repeated badgering and calling the defense attorneys outsiders, hired guns. So it's a different standard, but I think that even without an objection, that you would have something like in Warren, where, this guy is twisting the facts, the prosecutor, the defense attorney is twisting the facts, basically saying disregard the entire defense case. I mean, the prosecutor has a duty to ensure a fair trial. That doesn't end when defense counsel missteps here. And I think the United States Supreme Court in Young made that clear. Look, this is an obligation you have. You don't get to, take off whatever the rules and the constitutional protection simply because defense counsel made a mistake. And as you said, the court recognized it. This prosecutor got the remedy that he wanted. And so here he just continued to badger and tell the jury, basically, I'm right, he's wrong. He put the defense on the wrong side of the law, and he put the state on the right side. In similar to in Fredrickson, where
but Ms. Elner, you're still not answering the question. Why would an instruction not have cured this?
Okay, so an instruction wouldn't have cured because the prosecutor hammered. If he had objected, you're calling him a liar, all right? So he runs the risk of kind of highlighting objection, Your Honor, sustained, disregard. This guy he made a lie, another lie. Objection, Your Honor, sustained, disregard. So every time he highlights it, it's imprinted. And we know that we don't know what juries do all the time. Sometimes they follow the directions, but I think there were 7 or 8 different violations here that would have had to been objected to, which would have highlighted this, this misconduct to the extent that I have no confidence, nor does case law say a jury's going to disregard and actually listen to what the judge said rather than go back to the jury room and think about
Let me rephrase your
everything that was
argument.
highlighted?
I want to rephrase your argument to make sure I understand it. You're saying that the prosecutor put the defense counsel in a position where he or she, I'm not sure which it was required to object 5-6 times during closing, which would have made counsel look bad, and that's an untenable position in this situation.
Well, that's yes, and I think the argument, as this was the type of misconduct that was designed to appeal to the passions and prejudices of the jury. It invoked matters outside the record. The prosecutor expressed his personal opinion, and no objection could have cured that. And, you know, Judge Melnick, we might disagree on that, but that is the position that we take, that this was egregious. This was not borderline, and I think it's evidenced by the unpublished case where this prosecutor did the same thing. You all did not find misconduct, but in that case, the prosecutor was more careful. He said, let's look at the evidence. This argument here is you can't make it up, because let's look at the evidence. In this case, the prosecutor could have done the same thing. He did not have to bring in matters outside the record. He did not have to express his opinion. He could have said, let's look at the evidence.
So again, if I can just interrupt, let me see if I'm understanding your argument. And that is that the prejudice here individually would not require reversal, but cumulatively it would?
No, I think each one required individually was adequate. That I think this prosecutor in every instance made it clear that the defense was entirely wrong and the state was right. And he hit the defendant, defense attorney, supported the victim. He did everything he wasn't supposed to do.
Okay,
right? This wasn't a close case.
Okay, so let me ask you. So let me ask you a question, because now I'm getting confused.
I'm sorry.
It's not you. It's maybe me. But if the defense attorney had objected at the first improper argument, you're saying that no instruction would have cured that either?
No, and I also think that back to what Judge Lawrence Berry was saying about was strategically, you know, he objected to being called the first argument about the ethics book, but then the prosecutor continued and he objected again, and the court overruled it, telegraphing, I'm done. This guy's, I'm going to let him say what he wants. I mean,
you're way into your rebuttal time. I was trying to get you to, I don't know if you're aware of it, but you're into your rebuttal. Do you want to reserve the rest of your time?
Sure.
Okay, good. Thank you.
Thank you.
Ms. Hanlon?
Thank you. May it please the court, my name is Tamara Hanlon. I represent the state of Washington. I think we need to be clear about what the facts are here. The trial attorney never called the defendant a liar, didn't even say he lied, never asked the jury to do anything other than find the elements committed beyond a reasonable doubt based on the evidence. Never told the jury that it was their responsibility to determine who was telling the truth or not. All the credibility arguments that the trial attorney made are permissible. The state is allowed to argue all of the factors in the instruction regarding credibility, and she did that. And she tied all of those factors to the evidence in this case and went through them pretty methodically. So just to get that out of the way, we need to look at the facts and the record very clearly in this case as to what exactly was said.
So counsel, I'm concerned, and I just want to jump right to it.
Sure.
My understanding from reading the record is that the defense attorney started arguing about some recordings. The state objected, the court sustained the objection and struck it from the record. Subsequently, in rebuttal, the prosecutor then argues to the jury about that very argument made by defense attorney that's been stricken from the record. Is that correct?
She does point out the recordings and why she did not present those recordings. Correct. She did respond.
Isn't it true that that had already been stricken by the court?
Yes, the court
So
did.
Isn't that improper?
I think part of it was improper, where she mentions that the defense attorney was wrong in arguing that and that it was not a legal argument. However, there was no objection. So we're at this higher standard where we're talking about uncurable prejudice. And if we look at all of the cases that have been cited in the briefing, there's only two where the court found that the prejudice was uncurable, and that's Bellegarde, where there was discussion about the defendant being a deadly group of madmen and butchers that kill indiscriminately. So we're talking about serious misconduct where there's no.
So are you? Let me just be clear again, because the brief says something differently, and I know you didn't write the brief. So are you now saying that that argument by the prosecutor was flagrant and ill-intentioned and is improper?
No, I think that's consistent with the briefing. The argument went over the line by attacking the defense attorney. So the state conceded that in the argument that the defense attorney went too far. We conceded that in the briefing, and that's our position today. However, this was not the type of prejudice that meant it was uncurable. The court could have stopped at that point and said, okay, jury, disregard.
So we don't even get to prejudice unless it's flagrant and ill-intentioned, correct?
Correct.
So you're claiming, or your position today is that when the prosecutor argued and held up the book that's about ethics, and I understand the brief says something differently, but that's what the record says, that was not improper or was proper?
The case law on this indicates that we look at whether it was ill-intentioned or not by looking at the effect it had. So we don't look as much as what happened as the effect on the case and on the trial.
So do you think it was improper for her to argue that had already been stricken by the court earlier?
I think it was improper to go as far as she did in arguing that the defense attorney knew that it was an improper argument. But I think that the prosecutor is allowed to rebut, she's allowed to rebut what the defense attorney says. She's allowed
but not if it's stricken from the record. Are you saying that if it's stricken from the record, she still can rebut what the defense attorney said?
Well, I think he was attacking the defense investigation in other areas as well. So this was an overall theme of the defense attorney to attack not providing DNA evidence and not calling therapists. So I think in response to this overall theme that there's a lack of an investigation, I think that was proper.
Well, what she argued is, so for Mr. Dickerson to stand in front of the 14 of you and say, oh, the state didn't play those interviews for you, and they could have, but they're keeping them from you. He knows that's wrong and that's not a proper argument and not legal because I can't. You know why? They're hearsay. And that goes all to the evidence or to the argument by defense counsel that she objected to and was sustained and stricken. So is that improper?
Well, I agree in the sense that it went too far. And so we agree with
improper.
Yes, it was too far. Correct.
But you don't think it's flagrant and ill-intentioned?
No, because if you look at the case law in terms of what cases have been reversed based on misconduct, they're really inflammatory comments. Again, if you look at the facts.
That goes to prejudice, correct?
Correct.
So you can't conflate, because the test is if it's flagrant and ill-intentioned, then you look at prejudice and whether an instruction. But there's different parts of the test. We can't conflate the two, correct?
Well, I guess I would disagree. I think there is some case law that says you actually look at the effect to determine whether the comment's flagrant and ill-intentioned. You look at the effect because it makes it clearer for the court in terms of finding. I mean, how do we know what the intents are of a prosecutor? So I think there is case law that indicates we look at the effect and not just because we can't figure out what the intent of the prosecutor was to say it was ill-intentioned. So looking at the effects, we have to go to the cases and look at what effect some of the other comments had that were found to be reversible. And these comments simply do not amount to the type of prejudice and the prejudicial inflammatory comments that have been found to be reversible. And we can look at Glassman, again, where the prosecutor is telling the jury, in order to convict, you have to do something. And the words guilty, guilty, guilty superimposed on the PowerPoint numerous times. So we have really egregious facts that result in reversal. But when we look at all of the other cases, the court says these errors could have been cured. We could have had an instruction that said disregard, and then the jury's presumed to abide by those. In fact, in this case, if we look at some of the first objection that the defense made that was sustained in the state's rebuttal, the state didn't belabor the issue, but basically went on to explain, my argument is not evidence. So the follow-up from the state was not to push this issue. It was to clarify that what I say is not evidence, and you're to take in consideration what comes out of the microphone, the witness stand, and the exhibits.
So in this case, the prosecutor objects and the court strikes an argument. And the jury's told to disregard it. And now you're claiming that because they didn't strike it, it's prejudice? I mean, I guess the rebuttal argument goes towards something that's not in evidence and not argued. And now you're saying that's what the prosecutor did. So I'm confused.
Sure. Again, if you look at the defense closing, again, there's an overarching theme as to what the defense, what the state did and didn't do. And they were very critical of what the state didn't do. So I think that the state is allowed to explain why they didn't do something. That is a fair response. Here's why we didn't.
Even if it's stricken from argument at the state's request?
I think Ms. Hanlon's point is that some of it was stricken, but some of it wasn't. And but I do think that some of what the prosecutor clarified to the jury actually was stricken. So you can't have it both ways. Some of it was stricken, some of it wasn't. The prosecutor probably delved a little bit too deeply in explaining why she did what she didn't. I think you've said it's improper, the length she went, the prosecutor went, and it's a close call whether it's flagrant or not, based upon the trial court sustaining the objection. But anyways, I'm trying to summarize what I'm hearing.
Certainly, and there were things that weren't addressed by way of an objection, such as the search warrant for the DNA. And the specific objection by the defense there was drawing legal conclusions for the jury. So that was the first objection the defense made in this case, which is subject to the typical standard, which is whether there is substantial likelihood it impacted the case. And here, these just don't arise to the level that our case law indicates would create prejudice by the standards that we have. Again, the defense has the burden to show prejudice. They have the burden also to show misconduct. That is on them to show. In this case, they simply have not done it. If you look at the specific facts and what the prosecutor said exactly in this case, and also look at the defense arguments and State versus Russell, the state is entitled to make a fair response to the defense arguments. So we need to look at that case law very clearly. The second objection and the rebuttal, again, was not objected to. That was regarding not hearing from psychologists and therapists. And again, the state immediately moved on, didn't dwell on it. This was we have to look at that in terms of the prejudicial effect. Was the state hammering away at these things, or did the state quickly move on after the objection was sustained or after the argument was made? So we have to look at that as well. And the fact that the prosecutor often referred to the evidence, tied everything into the evidence, went through the instructions. So there was no cumulative error here. If there was error, it was small.
Where do we draw the line, though, when we look at State v. Monday, and the state has the obligation to also represent the defendant, meaning they have an obligation to make sure the defendant receives a fair trial, and you have improper, in my opinion, improper comment after improper comment after improper comment, and we're saying, well, the defense never objected. At what point do we just say the state crossed the line with all these comments, because they have that obligation to ensure the defendant is receiving a fair trial?
Sure. Again, the state would disagree that there were a lot of comments here. There were a few isolated comments, but in terms of the record, again, the comments about credibility were all legal and ethical comments that a prosecutor could make. We're talking about a case that comes down to credibility. So you're talking about the victim's credibility repeatedly. You're talking about the defendant's credibility. So there are not a ton of comments here that were problematic in this case. The comment regarding, some people think that being accused of a sex offense is worse than a murder charge. That has to be taken in the context of the case and the argument. And the argument the prosecutor was making there was, if you're charged with a serious offense, such as rape or even murder, you're going to be forthwith about some defense you have at the beginning and not bring it up at trial. So again, you have to, a lot of these statements are taken out of context, but you have to analyze it in the context of the evidence in the case, the argument, and the instructions. And here again, if you look at what the prosecutor's arguing with that response was, this was a serious case, a serious charge. And if you had a defense to it, that would have been provided up front rather than a trial. So again, there is a line to be drawn, but this case did not go over that line. We know that based on the case law and the facts of other cases where prosecutors have done a lot worse in this case, and it's still been upheld. And again, only 2 of the cases where there was no objection was there reversal that had been provided in this briefing, and those were very egregious facts. This is not any appeal to racial prejudices, stereotypes. She's not telling the jury to do anything other than to convict based on the elements. So we have to look at this case in light of all the other case law out there, and this just does not reach that level. Yes, the prosecutor went too far, but it was not reversible error in this case.
So I do have a question. It sounds like you're kind of breaking there. In the brief, not you, but the state argued the fair response rule. Are you withdrawing that argument? You haven't talked about it, or can you explain how that operates in this case?
Well, sure. So in the rebuttal, the defense says, or the state says, basically talks about the search warrant for DNA. So the state can address things that the defenses are missing in the case. So there's no search warrant. There's a missing witness. I think the state's entitled to explain that as a response to that argument instead of leaving it out there as to why we don't have therapists testify. So the state is not maintains that argument that you can have a strong, fair response to a defense argument and explain why we didn't get DNA. You know, maybe why a witness wasn't here. And the defense do the same when the state doesn't call something.
Okay, but I thought they were also, the state is also arguing fair responses to the comments about the interviews. Is that correct? Right around page 30 of the brief?
Yes, I'm on page 30 right now.
So talk to me about the fair response rule in relation to that.
So the state, again, doesn't have to or can't submit recorded interviews because of the hearsay rule. So I think the state can say, hey, we didn't give this to you because of the hearsay rule. And that's what the state was trying to do when they went too far and attacked defense counsel.
So again, and I understand you didn't try the case. I understand you didn't write the brief. However, you can't, or explain to me how you can apply the fair response rule to an issue that's been stricken by the court. How can you respond to that when it's been stricken by the court and the court's instructed the jury to disregard it?
Well, there's another issue the defense made about the therapist not being called and not being there too. So I think it does tie into that as well. So there's an issue the defense raised about the state not calling the counselors. So I think it ties into this whole general theme that the state hasn't done enough in the case.
Okay, so would you concede then that the fair response rule doesn't apply to the recorded interviews?
I think this state can address why we don't have more recorded interviews. I don't think that's an improper argument based on this overarching theme of not calling certain witnesses and not providing DNA. Unless there's any further questions, that's all for the state.
Okay, thank you. Ms. Eleanor, you've got 2.5 minutes, 2 minutes, 40 seconds.
So I'd like to just focus on, I think that we have all missed the fact that the arguments that this court is most concerned with were objected to. One was sustained, one was overruled. We are not talking about flagrant ill intention. We're talking about the standard. Was there a substantial likelihood that that misconduct affected the verdict? This is not a Reed case. This is a Reed case. There was an objection. It was overruled. Okay, so it's a lower standard. Under that standard, when the prosecutor argued defense counsel was unethical, was making arguments that were not legal, that he could not do, you don't have to, it doesn't have to be flagrant and ill intention. I think it was, but that's not what this court needs to evaluate. It needs to evaluate, is there a substantial likelihood it affected the verdict? I think the answer is yes, it is. I think it's also flagrant and ill intention, but for that misconduct alone, it's a lower standard. And so, you know, I don't think any of us have discussed that or really focused on that, but that's a different matter. I think the other was flagrant and ill intention. It was not a fair response. As Judge Melnick said, once the objection was sustained,
So,
There was
so
nothing to respond to.
can you cite to any cases where there's an objection to the closing, the court overrules it, and then the court finds that that was still improper?
I'm sorry, which court? So Reed, there's an
So the
objection.
trial court overruled the objection
Yeah,
and said the prosecutor, it's fine. And you're saying that the court erred by making that ruling.
yeah. Reed is the case. Objected to, and the court overruled.
Okay.
And the Supreme Court said, no, this affected the verdict. You cannot disparage counsel this way in front of a jury. It denies the fundamental right to a fair trial, period. There's no fair response to anything. It's outside the record. Doesn't matter where they come from or what kind of cars they drive. So I think that Reed is the case for this court to analogize these facts to. It is similar, but I think that this case is more egregious because of the nature of the case and the fact that you had vouching for the victim, you had language stating the prosecutor believed the defendant was a liar. So based on this entire case, I think under the lesser standard, you have prejudicial misconduct, and we would ask this court to reverse and remand for a new trial on that basis.
Following these arguments, the court affirmed the trial court's decision. Please let me know what you think about this case in the comments below. And if you like this video, please hit subscribe for new arguments every week.